Thank you. Yeah, I have notes. Sorry. The last time I was in this hall, I think it was about 30 years ago at a young farmers' dance, and it was certainly a lot rowdier than it is today. So today I'm going to talk to you about legal patterns, claims trends, and the impact of new technology on the sort of work that we do in the claims sector. Thank you very much for inviting me here today. My name's Elizabeth Bauer. I'm a partner and head of casualty claims and the team at Forbes Solicitors. We're a Northwest-based firm, but we act nationally and locally for over 60 local authorities and all 10 of the Greater Manchester authorities, dealing with their highway claims and a wide variety of other issues, including environmental, social services claims, housing, and employment liability. And today we're going to look at the impact of changes in the sector from a claims perspective and what we see as the current challenges and future developments. So, we're going to take a brief look at what the impact has been of the risk-based approach to highway management on claims since its introduction in 2018, and also going to look at other areas where we've seen changes in developments which impact on both our handling of claims but also on our clients' resources and budgets, which is obviously of crucial importance to you. Highway claims, we know, are a major element in national and local government third-party claims liability budgets, and there's a massive drain on resources, particularly for local authorities with large deductibles. Local authorities are thought to spend between £100 and £500 million a year managing highway claims, and even if you have a great system with a spot-on maintenance regime, with a rigorous and consistent inspection system, whilst you may not pay out on a lot of claims, you still have to deal with the claims that are being made. And if your systems are inadequate, and then the costs in terms of human and monetary resources can be absolutely massive, as we know. The new code was, of course, brought in to replace the previous codes, well-managed highways, well-lit highways and management of highway infrastructures in 2018, and the new code changed the approach from a reliance on specific guidance and recommendations to a risk-based approach by each local authority. We expected that following the introduction of the code that there would be an immediate challenge from claimant solicitors, particularly in relation to discretion given to highways inspectors on repair times and decision-making around whether to repair a defect which met or was close to the intervention level, and we were all quite excited about that. We, in collaboration with our clients, provided training, mock trials to review how the evidence was going to pan out in court if that was challenged. We reviewed statements and how we dealt with those in the past and how that was going to look in the future. We looked at evidence. We assisted in the review of the new code from a claims perspective and ensured that our clients and ourselves were all really well prepared for whatever the claimant solicitors were going to throw at us. We're all very excited. So effectively bring it on, because I love a good fight and we run a lot of cases to trial and we love to win. Running cases to trial sends out the right message to the public, that you protect public money, that you don't pay out spurious claims, but also sends out the message that you aren't a soft touch to claim farmers, of which unfortunately there's still rather a lot around. I remember one of the partners in a large firm of claimant solicitors in the Northwest speaking to me about a particular client of mine, and he said that effectively he was no longer going to pursue this particular local authority because they were just too hard work. He wasn't getting anywhere with claims, and that's the sort of response that we want from claimant solicitors, that we want them to be moving elsewhere. So on the face of it, given the interpretive nature of the new code, there's more scope for claimants to challenge whether the authority has done what it was reasonably required to do to secure the relevant part of the highway wasn't dangerous. And equally, there's more scope for the authority to justify whatever it was doing, provided there was a positive consideration of the new code. Interestingly, the type of claim we've seen has largely remained the same, and we haven't seen a lot of challenges to the risk-based approach itself. That's probably, I think, partly because our clients were so well prepared at the start of the code coming in, but also because that stems from the claimant solicitors themselves. Over the years, claimants' firms have dumbed down the work of highway claims in particular, so that it's carried out in the main by unqualified staff who have little or no knowledge of the law, tactics, or the issues surrounding the Highway Act. That can be very frustrating from our perspective, but also means that technical challenges are quite rare. We're still seeing the standard type claims, and the defence of those claims has largely remained the same. But that isn't to say that there won't be more challenges going forward. After all, we're not that far into the life cycle of claims when the code only came in 2018. So the standard sort of arguments we've seen for claimants: inadequate frequency of inspection, inappropriate intervention levels on roads, inaction, failure of or inadequate repairs, and defects arising from utility apparatus, inappropriate repair times. So those are the standard things that we're still seeing. Occasionally, we do get more interesting challenges, although they are the exception rather than the rule. And the main area that I've seen some interesting cases is in relation to the suggestion that the local authority should change the frequency of inspection where there are long-term roadworks nearby. So a particular case I dealt with not that long ago in Manchester County Court, it was a multi-track case. The claimant had suffered quite significant facial injuries. She'd fallen coming out of a public house at night, probably had been consuming quite a bit of alcohol, and she fell behind a taxi that had come to pick her up. The road was a fairly narrow country road, no pavements on either side of it, and it had been used over the last few months as a rat run to avoid road works on a major road. The intervention level on the minor road was 40 mil, and there were no pavements on either side of it, and the frequency of inspection was annually. The claimant solicitors tried to argue that because there were roadworks on the main road, that they should have increased the frequency of inspection on that minor road for the period of the time that the roadworks have been taking place. We successfully defended that, and the claimant lost at trial, which I think hopefully sends out the right message to other claimants that that's not an approach that's going to be appreciated by the court. But even if we hadn't succeeded on that, the argument on the intervention level, what they tried to say was that because there was no pavement on either side of the road, that the whole of the road should have had an intervention level of 25 mil rather than 40, which again was thrown out. So yeah, good result. But that it was quite a scattergun approach that the claimant solicitors took, trying to just throw anything at it to try and get a result. So what are we seeing in trends? There's been extensive media coverage given to the citizens' rights to claim from highway authorities in cases of accident or injury on public roads, and that's not changed for a very long time. The RAC, I note, has even got a page highlighting different kinds of potholes as photographs with catchily titled pictures of different ones, promoting people and encouraging them to report potholes using the free mobile app Stan, which can map potholes using a smartphone. And people are encouraged to report potholes at every opportunity. The problem is that they aren't given any advice as to whether or not there's a viable claim as a result of that pothole. So an awful lot of people think that if there's just a very small pothole in the road, that then they can make a claim. There's no consideration of the fact that whilst the highway authority is responsible for the maintenance of the road, then there is the Section 58 defence that if they can show that the local authorities taken such care as is reasonable in the circumstances to ensure that the highway is not dangerous for traffic, then there's going to be a defence. We continue to see high-profile advertising on TV. Hospitals, GP surgeries, local papers, national and local radio were bombarded by information. Claimants can use digital channels and apps to report claims and do. And it would have to be accepted that although across the country that there has been deterioration in the roads caused by weather conditions, and there's also an issue with perceived lack of resources and failed repair. We've noted, linked to the media interest, an increase in freedom of information requests, and the public, of course, have a statutory right to access personal injury held by non-personal information held by local authority. And that press interest has resulted in a lot of articles concerning the huge amount of money and resources used to deal with highway claims and repair times. And that only encourages claimants and claimant solicitors to pursue highway authorities already under pressure to prevent claims. And that in turn can have an impact on fraud-related claims. Highway authorities are particularly vulnerable to fraud because there's often no independent witnesses or no real independent witnesses who can give corroborative evidence to support the claim that an accident actually happened. Highway authorities obviously have an obligation to treat legitimate claimants fairly, but they also need to weed out fraudulent elements at an early stage. And we triage claims for a lot of our clients to identify cases of concern where there may be fraud issues identified very early on. And we've been very successful in partnership with our clients in defending claims and obtaining findings of fundamental dishonesty, which again sends out the right message. So what is the current picture from a claims perspective? Well, one of my clients has very kindly provided me with this graph showing their claims experience from 2016. You probably can't see all the figures at the bottom, but it starts at 2016, goes right up until August of this year. You can see a huge spike in 2018, that's the biggest one, which was due partly to the beast from the east in February of that year, but the claims were on the rise even before that. And then the graph shows a seasonal reporting pattern. COVID obviously played its part in the reduction of claims, but what we're now seeing is a further rise in claims again, and certainly over the last 12 months, a significant rise. Some of that may be due to the reforms in other areas, such as road traffic accident whiplash claims, with claimant solicitors looking for other income streams where they're going to make more money, but also social media and press interest driving claims up, coupled with issues with repairs. So fraud, unfortunately, is on the rise. There are a lot of horrifying statistics being bandied about at the moment, and it certainly seems the case that there is a rise in both organised and opportunistic fraud. Zurich, one of the insurers who we act for, says that in the extreme weather conditions did cause a rise in the number of road defects last year, leaving greater room for opportunistic fraud to falsely claim that potholes had caused vehicle damage to vehicles that was already in existence, but also in relation to personal injury claims where people have suffered injury elsewhere and then claimed that they've fallen in a pothole on the road. It's estimated that the insurance industry spends over £200 million a year on identifying and preventing fraud. Technological advancements, including the rise of AI, allows us and insurers to cross-reference data and to map claims from multiple sources. And that gives us links to other people and to businesses right across all our local authority clients, and alerts us and insurers to any suspicious details. We've also seen an increase in organised fraud, seen a number of claims recently from one particular firm of solicitors in the Northwest who are currently targeting one of our local authority clients. That firm of solicitors has one particular claims handler who is Facebook friends with nearly all the claimants that we're seeing coming through, and they also have links to a fraud ring that we dealt with 5 to 10 years ago for two of our other clients, where we successfully managed to obtain findings of fraud and fundamental dishonesty. So those links are extremely important between local authorities, and also information is absolutely the key. If you can share information between local authorities and neighbouring authorities as to what claims you are seeing and who is putting those claims into you, then you've got half a chance of making a good indent into the fraud rings that we are seeing at the moment. So changes and developments. It's not all doom and gloom. Recent changes have meant that all claims up to £100,000 are now subject to fixed fees, and that enables local authorities to save money and to reserve more accurately on the amount of the costs of the claim that's going to be finalised. In May 2021, whiplash reforms introduced fixed tariffs for injuries and increased the small claims track for whiplash RTA claims to £5,000. That's meant claimant solicitors are looking elsewhere for income streams. And the small claims track limit is also increased for other personal injury claims to £1,500. What has made claims handling more difficult is the consequential increase in the number of litigants in person handling their own claims. Talk to any of the claim handlers in-house at the local authorities or with your insurer, and I'm sure that they will tell you how difficult they can be to deal with. They usually don't understand the system or the law, and the social media influence means that they assume that they will receive compensation whatever the size of the defect. And even if you provide a denial of liability, quite frequently they won't accept that, even if there's an explanation as to why they're not entitled to compensation, and they will kick back. Historically, usually claimants would accept a decision that liability was denied, but now they do tend to pursue them, and we see an awful lot of issued claims, which again really stretches all the budgets and the resources that local authorities and insurers have got. And whilst a lot of them are small claims, they still need to be defended appropriately, if necessary, to send out the right message again to the general public. So, AI. I've already mentioned that the industry uses AI in relation to identifying potentially fraudulent claims, and we also use it to identify trends. We're also aware, obviously, of the interest in AI in connection with identifying defects in the highway, and that it's being used in connection with driven highway inspections to identify defects more easily, particularly on more remote roads, and also in relation to road condition surveys. We can really see the benefit to local authorities in connection with inspection of rural roads, where walked inspections are going to be virtually impossible, and it's going to not be practical and a lot safer to use a driven inspection. It enables inspectors to identify areas of concern or particularly significant defects. Lawyers have used Google Images and maps for years in supporting Section 58 defences to show that a defect was or wasn't present at the time of the last inspection. So it's really only an extension of that as far as we are concerned, but much more sophisticated. Claims involving driven inspections can often be quite difficult to defend, because the court's often open to arguments that the defects can be missed on a driven inspection. Obviously, it can be more difficult to spot them. And when we defend claims, the evidence provided by the individual inspector to support the contention that the defect wasn't present at the last inspection is going to be crucial. And sometimes, obviously, those inspectors aren't available anymore. They may have moved on, they may have retired. So having some contemporaneous photographic evidence of what he actually saw at the time of the inspection will prove extremely useful. I suppose one of the things that might be more of an issue for us is, and something that it'll be interesting to see, is whether the defects are going to be obvious if the weather conditions aren't going to be that good, and if the defect's going to be filled with water. And also, we won't have a measurement of that defect. So sometimes that can be something that will sway the judge if he sees that something's not, that we don't have an actual specific measurement of it at the time of the inspection. He may be persuaded to fine for the claimant. So it's an interesting time, and we're monitoring case law closely to see if there are any cases coming along using the new technology or having it supporting the Section 58 defence that's already in place. The future with AI would be for it to calculate measurements of defects and would potentially have even more of an impact on the claims experience from our point of view. I'd also suggest that it would be sensible, if you are using AI on inspections, that you review your code of practice and to explain how that's going to be used within the code to identify defects, or if you're going to be using on routine inspections. And certainly fraudsters may find, as to an extent they have with Google Images, that AI footage may well assist in defending those sort of claims too. So in conclusion, the highway landscape's constantly evolving and changing, driven by legal frameworks, changing claims patterns and technology advancements. And the insurers and highway authorities that embrace these innovations while navigating the challenges that we all face at the moment will be best placed to manage their claims experience effectively. Thank you very much.